The defense of non-insane automatism, if successfully pleaded, acts as a complete defense absolving the defendant of all criminal liability. It differs from the defense of insane automatism in that there is no power to detain in a mental hospital, neither may any other order be made against the defendant. The defense of non-insane automatism exists where a person commits a crime in circumstances where their actions can be said to be involuntary. This could be where, for example, an involuntary natural reaction occurs, such as sneezing or being chased by a swarm of bees. A finding of non-insane automatism may also exist where the defendant is not conscious of their actions due to an external factor, often as a result of medication. The essential difference between insane and non-insane automatism is that for insane automatism, the defect of reason must be caused by an internal factor, whereas for non-insane automatism the involuntary action must be caused by an external factor. Case examples of where the defense has been successfully pleaded include R.V. Woolley, where the defendant suffered a sneezing fit. Losing control of his vehicle, he knocked into the car in front. This car in turn knocked into the car in front, causing a domino effect involving 7 cars. Also R.V. Quick and R.V. Bingham, where the defendants were suffering from hypoglycemia at the time of the offense, a condition suffered by diabetics if they have too much insulin. Post-traumatic stress disorder was also considered to be caused by an external factor in RVT. The defendant was allowed the defense of automatism as she was suffering from post-traumatic stress as a result of being raped. The requirements of the defense of non-insane automatism are: 1. There must exist an involuntary action arising from an external source or reflex action. 2. The action must be completely involuntary. And 3. The automatism must not be self-induced. 1. There must exist an involuntary action arising from an external source or reflex action. The involuntary action must not arise from an inside source, otherwise a finding of insane automatism will arise. For example, in R.V. Kemp, the defendant suffered from arteriosclerosis, a condition affecting the blood vessels restricting the flow of oxygen to the brain. This gave rise to a finding of insanity despite it being a physical disease rather than a mental disease, because it was an internal source. Similarly, epilepsy is also classified as an internal source and therefore would lead to a finding of insanity according to R.V. Sullivan and Bratty v. Attorney General for Northern Ireland. Even sleepwalking gives rise to a finding of insanity according to R.V. Burgess. Furthermore, hyperglycemia arising from diabetes also will result in a finding of insanity. However, hypoglycemia arising from the injection of too much insulin will amount to an outside source and therefore give rise to a finding of non-insane automatism according to R.V. Quick. 2. The action must be completely involuntary. For the defense of non-insane automatism to succeed, there must exist a complete loss of control. If the defendant retains control over their actions, the defense will fail as they are not acting as an automaton. In Broom v. Perkins, 1987, the appellant was a diabetic. He had driven erratically while suffering from hypoglycemia. His defense of non-insane automatism failed because of evidence that he had exercised conscious control over his car by veering away from other vehicles so as to avoid a collision. 3. The automatism must not be self-induced. If the defendant knowingly puts themselves in a position of automatism, then the defense of non-insane automatism will fail. In R.V. Bailey, the appellant, a diabetic, went to the home of his ex-girlfriend. She wasn't in and her new boyfriend answered the door. The appellant was upset and the boyfriend invited him in. He claimed he was feeling unwell and asked for some sugar and a glass of water. He then attacked him with an iron bar. He was unable to raise the defense of automatism as he deliberately took the sugar and water to induce the condition. Where the external factor is alcohol or drugs, the defense of intoxication will apply and will therefore be dependent on whether the intoxication was voluntary and whether the crime is one of basic intent or specific intent. In summary, non-insane automatism is a complete defense in criminal law. It is a general defense, applicable to all crimes. The defendant must establish that their action was completely involuntary due to an external factor and that the automatism was not self-induced. This video is part of a series of videos on law from www.e-lawresources.co.uk. Please subscribe to our YouTube channel www.youtube.com/@e-lawresources. It's free to do so and will help us to keep providing these videos. Check out our website, which provides lecture outlines and case summaries. See also www.elawrevision.org.uk for revision games and quizzes. Thanks for watching.